Welcome to your ultimate breakdown of the California Residential Lease Listing Agreement, Form LL, along with all the must-know advisories every agent needs. In this training course, you'll learn exactly how to navigate California lease agreements, stay compliant with 2025-2026 regulations, and protect your clients while closing deals faster and smarter. Let's get into it. As a quick reminder, this video has a written presentation to follow along. Don't forget to download a copy from my training website, so you can print it, follow along, study it, and make notes. The link to the training website to download this presentation is on the screen and in the video description. And if you enjoyed this training, be sure to subscribe, like, and comment. The lease listing agreement is the foundational contract establishing your professional relationship with a property owner. It clearly defines your role, responsibilities, and the terms of your compensation for securing a tenant. This agreement isn't just paperwork, it's a critical tool for setting expectations, ensuring all parties understand their obligations, and protecting your interests as a real estate professional. By mastering its intricacies, you build trust with your clients and facilitate a smooth, legally sound leasing process from start to finish. Broker compensation, outlined in Form LL Section 3, is fully negotiable and not legally fixed. This section details how your commission is earned for various scenarios, including fixed-term leases and month-to-month arrangements. It also addresses compensation when you represent an unrepresented tenant, ensuring your efforts are recognized. Crucially, pay close attention to the continuation clause, which protects your right to compensation for tenants you procured, even if a lease is executed after the listing period ends. Clear understanding here is paramount for your financial security. Beyond the standard compensation, Form LL addresses specific situations affecting your earnings. This includes provisions for tenant breach of lease, or if the property is subsequently sold to a tenant you introduced. These clauses clarify your compensation in less common yet significant scenarios. Additionally, the agreement outlines the procedures for handling tenant payments to the owner, including options for electronic transactions. Thoroughly reviewing these details helps manage expectations for all parties and ensures financial transparency throughout the leasing process. Operational provisions are practical necessities for effectively managing the property during the listing period. This section covers crucial aspects such as the use of key safes or lockboxes for authorized access, proper placement of for-lease signs, and the requirements for MLS listings to ensure broad exposure. It also touches upon vital security measures and insurance considerations, reminding all parties of their responsibilities to protect the property. Adhering to these provisions is key to a smooth, secure, and compliant leasing experience for everyone involved. This section clarifies critical tax withholding requirements, both at the California and federal levels, that may apply to lease transactions. It also delineates the distinct duties of brokers and property owners. As brokers, your responsibilities include diligently working to lease the premises, utilizing appropriate advertising channels, and ensuring compliance with regulations, such as those concerning digitally altered images. Property owners, in turn, must provide necessary documentation, act in good faith, make the premises available for showings, and comply with all health and safety laws. Understanding indemnity and agency relationships is crucial. The indemnity clause states that the property owner agrees to protect you, the broker, from liabilities arising from incorrect information or undisclosed material facts. This protection extends beyond the agreement's termination. Regarding agency, you represent the property owner in the transaction. If you also procure the tenant, a dual agency relationship arises, requiring explicit disclosure and consent. It's vital to know that your agency relationship typically concludes upon a lease agreement's execution and tenant occupancy. This section covers vital procedural aspects. It addresses dispute resolution methods, including mediation, as a means to resolve conflicts efficiently. It also emphasizes the importance of management approval, where applicable, ensuring that all necessary internal authorizations are secured. Finally, it outlines requirements for legally authorized signers, confirming that individuals executing the agreement have the authority to do so. Proper attention to these details ensures the agreement is enforceable and that all parties are properly bound by its terms. The Rental Property Owner Disclosure, or RPOD, is an essential document that accompanies your lease listing. It requires property owners to disclose all known material facts about the property to prospective tenants. Owners should answer based on their actual knowledge, revealing anything a reasonable person would want to know before leasing a property. This proactive disclosure builds trust and helps prevent future disputes, ensuring transparency in every transaction. It's a cornerstone of ethical and compliant leasing practices. The RPOD mandates several key environmental and property disclosures. If the building predates 1978, lead-based paint disclosure is required. Any history of methamphetamine contamination, including remediation status, must be revealed. You'll also need to disclose if a periodic pest control contract is in place and provide relevant notices. Furthermore, if the property uses water submeters for shared units, that information, along with compliance with state civil codes, must be transparently disclosed. These disclosures protect tenants and ensure compliance. Beyond environmental factors, the RPOD requires additional disclosures for properties. This includes information about mold, asbestos, and any homeowners association rules, or covenants, conditions, and restrictions. It also addresses the presence of military ordnance and any death on the premises as legally required. Finally, there's a general clause for other material facts, obliging owners to disclose anything else that could reasonably impact a tenant's decision. These comprehensive disclosures uphold transparency and protect all parties involved. The Rental Property Owner Advisory, or RPOA, is an invaluable resource for both new and experienced property owners. It addresses a wide range of legal and practical issues specific to long-term rentals, typically those lasting 30 days or more. For properties rented on a shorter-term basis, owners should consult the Short-Term Rental Advisory. The RPOA helps owners understand their obligations and rights, ensuring they are well prepared for the responsibilities of leasing their property in California. The RPOA clarifies crucial aspects of rent control and tenant protection laws. Many California cities and counties have local rent and eviction controls, limiting rent increases and regulating tenancy termination. Even previously vacant properties can be affected. Additionally, the statewide Tenant Protection Act imposes rent caps and just cause eviction requirements. While certain exemptions exist, such as single-family homes with specific notices, newer constructions, or owner-occupied duplexes, it's vital to understand which regulations apply to a specific property. Property owners have a fundamental responsibility to maintain habitable premises, including essential elements like waterproofing, plumbing, heating, and working smoke alarms. As of 2026, new leases must even include a working stove and refrigerator. Extensive disclosures are mandated, covering everything from water submeters to bed bugs. Notably, as of July 1, 2024, the maximum security deposit for most landlords is capped at 1 month's rent, with specific exceptions for smaller owners and active military tenants. This section details important operational guidelines. Starting April 2025, mandatory photos are required after tenancy ends and repairs are completed, with inception photos for tenancies beginning July 2025. Screening fees are CPI adjusted, currently around $62.02, and must be refunded if an application isn't considered. Properties with 16 or more units must offer positive rental payment reporting. Finally, remember that service and support animals are legally distinct from pets, meaning owners cannot charge additional deposits for them. This section covers vital practical and legal advisories. Notices emphasizes compliance with local and state laws for tenant communications. Insurance highlights the importance of liability and damage coverage, and often renters' insurance. During declared emergencies, rent increases can be capped. Elevated wood balconies notes inspection requirements for specific structures. Crucially, remember that as agents, you cannot provide legal or tax advice. Always direct clients to qualified California landlord-tenant attorneys and CPAs for such specialized guidance. The Fair Housing Advisory is a cornerstone of ethical real estate practice. It underscores the unwavering commitment to fair housing, ensuring equal access and opportunity for all individuals seeking housing. This advisory reminds us that discrimination in housing is strictly prohibited under numerous protected classes, spanning federal, state, and local laws. As agents, upholding these principles is not just a legal requirement, but a fundamental ethical responsibility in serving our diverse communities. Fair housing laws protect individuals based on an extensive list of characteristics, including race, age, religion, sexual orientation, disability, source of income, and even criminal history unrelated to tenancy. Prohibited conduct includes refusing to show or rent, discriminatory advertising, steering tenants based on protected status, or refusing reasonable accommodations for disabilities. Violations can lead to license suspension. Remember, limited exceptions exist, but always seek legal advice before relying on any exception to ensure full compliance. The California Consumer Privacy Act, or CCPA, grants California residents significant rights over their personal information collected by businesses. In real estate transactions, personal information, including property photos and sales data, is shared with many parties like licensees, the MLS, and title companies. The CCPA gives individuals the right to know what data is collected, the right to correct or delete that data, and the right to opt out of its sale or limit sensitive PI use. While powerful, remember that brokers and the MLS must maintain records for 3 years, regardless of opt-out requests. Before we end, and as a final reminder, this video has a written presentation to follow along. Don't forget to download a copy from my training website, so you can print it, follow along, study it, and make notes. The link to the training website is on the screen and in the video description. And if you enjoyed this training, be sure to subscribe, like, and share, and always remember to refer clients to an attorney, CPA, or other qualified professional for any specific legal or tax advice. To summarize, Form LL establishes your exclusive listing rights, negotiable compensation, and agency duties. Always complete all blanks and attach necessary addenda. The RPOD requires timely disclosure of all known material facts, from lead paint to HOA restrictions. The RPOA is crucial for understanding rent control, TPA exemptions, habitability, and new rules for security deposits and animals. Finally, Forms FHDA and CCPA mandate compliance with comprehensive fair housing laws across many protected classes and clarify consumer privacy rights. All these forms are CAR approved, but remember to consult legal or tax professionals for specific advice.